So wonderful morning friends, hope all of you fully geared up and also made full use of all the videos that has been shared. Just a quick couple of questions which I felt important I'll be sharing now, so that if it comes in as an exam you can get full marks on it. So when will the organization be considered as recognized in with regard to the valuation as per the recent amendments? So the when it conducts educational courses in valuation and grants membership or certificate of practice to individuals who possess the qualification experience, and it conducts training for the individual members before a certificate of practice, and it lays down and enforces a code of conduct. For here it is training, it is code of conduct for value members, and next is provides for continuing education of individuals. As you are well, I should be knowing the CPE hours which is there for CA, CS, etc. So the same thing, and monitors and reviews the functioning including the quality of service, and as a mechanism to address grievances and conduct disciplinary proceedings. So if you see, the main three catch terms are code of conduct, quality of service, and disciplinary proceedings. These are key terms you are expected to reproduce. And moving on to the few cases in IBC in with regard to the moratorium, which has got a lot of chance for coming. So first thing is whether moratorium can be applied to criminal proceedings. So the resolution provision has sought detachment of properties attached to the director of enforcement of the PMLA, considering the time prior to initiation. So in this case, the NCLAT held that Section 14 of IBC is not applicable to criminal or any penal action taken pursuant to criminal proceeding having the essence of crime or criminal proceeding. So this is very important one. And another important thing is whether moratorium applies on regulatory authorities. Briefly elaborate with the decided case law, they might ask. So Mrs. Anju Agarwal resolution versus Bombay Stock Exchange, the NCLAT observed that Section 28A of SEBI is inconsistent with Section 14 of IBC. It held that Section 14 of IBC will prevail. In the previous case, IBC does not prevail on criminal proceedings, but in this case, it will prevail over Section 28A of SEBI, and it cannot recover any amount including a penalty from a corporate debtor. The Bombay Stock Exchange cannot suspend trading of shares of CD for the same reason. So this is the question. Moving on to the next one. This is also on similar lines, where penalty imposed by regulator may be claimed as operational creditor but cannot be recovered. So in this case, the NCLAT held that the case is Maharashtra Seamless Limited versus Sri Padmanabhan Venkatesh and others. The NCLAT held that the statutory dues that is due to the central government or state government for the time being in force come within the meaning of operational debt. You must specifically mention this because these are the definitions as per IBC. And if penalty is imposed or an amount is payable to SEBI, in such case it may be claimed as operational creditor but cannot recover the same during the resolution process. So first is it is operational debt, second is it cannot be recovered during the resolution process, and if possible, if you mention this case, so this might come for 5 marks. So this are because this is small cases, so you are expected to reproduce certain things as it is, because these are all code terminologies, so that level of reproduction is required. And this quick few things which I want to share, because I have a lot of chances for these things coming. Keep revising and revise calmly. Don't let the exam pressure get onto your mind. All the revise keeping on the stage. I'm sure you're going to do really well today. So very good morning everyone. Let's quickly take a look at one very important case in IBC. So whether the AA had the power under IBC to review the order passed by the government of Karnataka during the moratorium period rejecting the auto extension of mining lease granted to it by the corporate debtor. So the Supreme Court, that is the Apex Court, observed that moratorium under Section 14 did not impact the right of government to refuse extension of the lease. So it observed that purpose of Section 14 was to serve the status quo. I repeat, purpose of Section 14 was to preserve the status quo and not to create a new right. This is very important. You can write this line even if another question comes relating to moratorium. And so Section 14 only prohibits during the period of moratorium the recovery of any property by the owner. It will not go to the rescue of the corporate debtor, since what is prohibited is only right not to be disposed but not right to have renewal of the lease. So these are the three, this para is very important with regard to this question, and it was observed that right not to be dispossessed will have nothing to do with rights conferred by mining lease. Hence, it was noted that what was granted to the corporate data was not an exclusive possession of the land in question, so as to enable the RP to invoke Section 14 only of IBC. Lot of chances for coming in question 6. Embassy property developers, private limited or state of Karnataka. So do watch out for it, and do watch the previous valuation video IBC shared. So all the very best once again.